The training coordinator for CTAS. I would like to thank you all for joining in today's class. And today's class is called First Amendment Audit and Open Records. If you logged in early, you would have had the information, or seen the information about using your webcam and microphone in today's Zoom, as well as heard some pretty jazzy music to go along with it. So today we want to ensure you receive proper credit for logging on today's session. So make sure your full name is showing on Zoom today. I want to stress that a bit more. It does not need to say iPad or just your first name. We need to see the full name that you're using, Kate, when you register. Not only does this ensure proper credit, but it also helps our instructors interact with you. Feel free to use the chat feature to submit your questions, comments, or direct messages to an individual at any time during the presentation. And also, any technical issues you experience can also be typed in the chat, and someone from CTAS can assist you. Now, I just want you to take a moment to type in your full name and county in the chat. Also include anyone that may be watching with you. And also keep in mind that we need to see them on camera as well. This also ensures that we have a clear and accurate roster to make sure everyone receives credit today. There is also always a chance that streaming media can be disrupted, as we know, based on your connection. So please be patient as you may experience sound breaking up or slides not advancing. If you drop off of Zoom, it should restart. If it does not, please use the same link you used to enter the meeting again. If the class has already been locked, and it usually locks about 10 minutes after we begin, please give me a quick call at 615-200-3237 so that I can help you get back in. And I'll repeat that number again, is 615-200-3237. And I'll also put that in the chat in just a few moments. And again, my name is Kim. So as a reminder, to receive COCTP credit, you must be visible on camera the entire class. Staff from CTAS will monitor this for the duration of the session. Your facilitators today are Jim Hart and Jeff Metzger. I ask that you give them your full attention and refrain from potential distractions. Lastly, please hold all of your questions until the end of the presentation, as they will have a Q&A time at the end. I will now put you in the hands of our instructors today, Mr. Jim and Mr. Jeff. So it's all yours, guys.
Thank you, Kimberly. I'm Jeff Metzger. I'm an attorney with CTAS. I'll start off today with the open records portion, and I think then Jim's going to come in some with the First Amendment audit information. I appreciate you all being here today. I'm going to share my screen because I have a PowerPoint here that I want you all to see. Bear with me one second. There we go. All right, under the open records law, while you are in charge of maintaining them, the records of your office are technically public property. Generally, the public must be given access to the records in your office. However, some records are confidential and must be protected. Tennessee's open records law can be found at Tennessee Code Annotated 107503. It provides that all state, county, and municipal records shall at all times during business hours be open for personal inspection by any citizen of Tennessee, and those in charge of such records shall not refuse such right of inspection to any citizen unless otherwise provided by law. All right, this slide contains the legal definition of public records. This is an extremely broad definition that covers every possible way you can record information. There are a couple of caveats I want to make though. First, while every document in your office is a public record, the device that holds that document is not. So let's say, for example, if you send an email on your computer about a county project, that email is a public record, but the computer itself is not. Thus, no citizen can demand access to your computer. The second caveat, somewhat related to the first, The definition states that a record is public if it is made or received in connection with the transaction of official county business. So going back to our email example, if you send an email about a county project, that is a public record. However, if you send a personal email to a friend unrelated to county business, that is not a public record and no citizen can demand access to that email. All right, some examples of records that may be open to the public include employee evaluations, contracts with vendors, emails, phone messages, financial performance audits, annual reports, fee collection reports, meeting agendas and minutes, budgets, and office policies. All right, while the general rule is that all records are open, there are numerous laws which make certain documents confidential. While many of these exceptions can be found in Tennessee Code Annotated 107504, most of them are not. Exceptions can be found in other statutes, in the common law, the rules of courts, administrative rules and regulations, and in federal laws. When the Public Records Law was first passed in 1957, there were only 2 statutory exceptions. This number grew to 89 exceptions by 1988. This number has now grown to almost 600 total statutory exceptions. Some examples of confidential records include Social Security numbers, student records, much of the information in motor vehicle records, credit card numbers of people doing business with the county, adoption records, and investigative files pertaining to pending or contemplated criminal action. All right, one important class of confidential records includes the personal information of county employees. Most of the personal information of county employees is confidential. This includes their home and cell phone numbers, bank account information, health savings account information, retirement account information, pension account information, social security number, residential address, driver personal email address, and emergency contact information. Also, similar information for the employee's family and household members is also confidential. Finally, these confidentiality provisions also apply to former employees or even applicants for employment. Okay, just because a record contains confidential information, that does not mean the entire record is confidential. If possible, you must still provide access to the record after redacting all the confidential information. So for example, if someone requests a document that contains an employee's name, salary, and home address, you would redact the address and provide access to the rest of the record because the employee's name and salary are not confidential. To redact information from a document, it is recommended that first, a copy be made of the original. Second, on such copy, black out the confidential information with a marker. Third, make a copy of that blacked out copy. And fourth, provide the copy of the blacked out copy to the requester. The first copy is necessary because you should never redact an original document, since that would forever alter the document. The second copy is recommended because just blacking out the information with a marker often still allows the information to be read if closely inspected. For assistance in determining whether a record is confidential or not, county officials may contact the Office of Open Records Counsel. On this slide, I have provided the office's website address and phone numbers. I've also included the fax number and email address. All this information can be found by simply Googling Office of Open Records Counsel, or you can, of course, also contact your CTAS representative for the information. The Office of Open Records Counsel was created in 2008 and has been charged with the duty of answering questions from county officials and citizens regarding public records requests. Additionally, the Office of Open Records Counsel provides advisory opinions, training, forms, and best practice guidelines to assist you with responding to records requests. All right, what process should you follow when a citizen requests a record? The law provides that citizens have the right to request both inspection and copies of public records during normal business hours. If it is practical to do so, you must promptly make the record available once it's requested. However, if it is not practical to immediately make the record available, you must within 7 business days either make the record available, deny the request in writing stating the basis for the denial, or 3, furnish the requester in writing or by completing a records request form developed by the Office of Open Records Counsel the time reasonably necessary to produce the record. All right, so for example, if someone walks into your office and you are not very busy and they request a common form that you can easily access, you should go ahead and give them the document then and there. It would not be appropriate to tell them that you have 7 business days to reply to their request. However, if someone walks into your office and you are very busy and they request hundreds of personal records that will require heavy redaction, it would be appropriate in that situation to let them know that you will start working on putting together those records, and they will hear from you within the next 7 business days regarding which records you can provide and how long it will take you. All right, if you deny a citizen access to a public record, they can go to court and sue you. If they go to court, the judge will issue an order requiring you to come to court and explain why you denied access to the record. And in this situation, you, not the citizen, will have the burden of proof to justify the reason for not disclosing the record. If the court easily amount to $50,000 to $60,000. Willful in this context doesn't mean that you knew what you were doing was wrong. Courts interpret willful to mean that you didn't have a good argument under the law. Thus, a court can find your denial was willful even if you believe the record was confidential. One important rule in making this willful determination, the law requires the court to consider any advice given you by the Office of Open Records Counsel. So if you're not sure whether to turn over a record, you can provide yourself some protection by contacting the Office of Open Records Counsel and following their advice. Okay, next, charging for copies of public records. First, citizens cannot be charged anything to simply view a public record. This is true even if you have to spend hours redacting confidential information. However, you can charge your actual cost for providing copies of public records. Prior to making such copies, you should provide an estimate of the total cost to produce the copies. Finally, the Office of Open Records Counsel has developed a schedule of reasonable charges which you may adopt for providing copies of public records. The Office of Open Records Counsel's schedule of reasonable charges can be found on the office's website. In short, the schedule provides that citizens may be charged 15 cents per page for black and white copies and 50 cents a page for color copies. Additionally, the hourly wage of the employees used to produce the copies can also be charged after the first hour spent working on producing the copies. You might want to strongly consider charging according to the Office of Open Records Counsel schedule because the General Assembly has provided a safe harbor for county officials who charge according to the schedule. If you charge according to the schedule, courts are to deem such charges reasonable. However, if you do not charge according to the schedule, you must document that such higher charge represents your actual cost of producing the copy or that you are charging pursuant to other statutory authority. Okay, there are several limits on records requests. As mentioned earlier, the public has no right to view confidential records. Additionally, only Tennessee citizens have a right to request records. To determine whether the requester is a Tennessee citizen, you may require the requester to present a valid Tennessee driver's license or other reasonable form of identification. Additionally, you are not required to create a document that does not exist or sort through files to compile information. The law simply provides that you must turn over access to the public records in your office. The law does not require that you provide citizens any research support. Also, you are not required to produce a document for which you are not the custodian. you may simply direct the requester to the proper custodian for that record. Okay, a few years ago, the General Assembly passed a law requiring all county entities to adopt a written public records policy. This policy must include, first, the process for making requests to inspect public records, receive copies of public records, and a copy of any required request form. Second, the process for responding to requests, including redaction practices. Third, a statement of any fees charged for copies of public records and the procedures for billing and payment. And fourth, the policy must designate a public records request coordinator that citizens can contact when requesting records. The law required the Office of Open Records Counsel to publish a model policy that counties can use, and CTAS has a model policy completion checklist that you can help use to complete the Office of Open Records Counsel model policy. I recommend you confirm you have an adopted policy in effect and that you review the policy so that you can comply with your adopted policy when responding to records requests. Okay, the last thing I'll talk about is a law that just passed last year. The General Assembly passed a law that amended Tennessee Code Annotated 107503H. It provides that a county cannot destroy any document subject to a records request. Prior to destroying records, you must contact the Public Records Request Coordinator to confirm that documents are not subject to a pending records request. Violations of this law can result in a $500 fine. The law also provides that counties are to maintain all correspondence and attachments related to requests for at least a period of 12 months. All right, that's it for me. Now I believe Jim is going to come on and talk to you some about the First Amendment auditors.
Morning, everyone. My name is Jim Hart. I'm the interim manager for field services and also the jail management consultant with CTAS. I'm going to talk about First Amendment audits today that is seems to be going across our state and across the country. First Amendment auditors are individuals who basically come onto public property and their goal is just to test their rights to be in a public space, to film or to photograph things that are within public view. And this is, as such, it has forced law enforcement, public officials to start thinking about how do we respond to these types of audits. Some of the research that I did for this particular presentation includes some auditors are believed to be testing the resolve of law enforcement. Just to see what will happen, how will they respond, how will public officials respond to the challenge of this person being in your area. Some people argue that these auditors are just trying to bait public officials into a disagreement, into an argument, or to violate their potential or their perceived rights. Looking at everything that I've researched so far and looked at indicates that it's probably a combination of both of what they're trying to accomplish. Many audits are nonviolent, they're uneventful. There's some positive interactions between the auditor and between the public official or between law enforcement. But some audits do escalate quite rapidly, resulting in potential arrest, seizure of equipment, or possible litigation against a county. The audits you can find, you can Google YouTube and find quite a bit of results of audits out there. They look at this as a form of activism. They believe that they will stake out a public facility and record the location, record their interactions with you, record the interactions with public citizens that they encounter. If there is an uneventful incident that occurs or uneventful actions that occur during this process, they will look at that as you having passed this audit. However, if they're challenged, if they're challenged inappropriately or they're detained or items are confiscated, they typically will provide or recognize this as being a failing audit. They don't appear to be connected to any specific organization. Rather, it's just individuals who've decided that they're going to test their First Amendment audit, the First Amendment rights to these various auditing or videoing procedures. One of the things that you think about, or when an auditor is denied the right to film, or denied the right to be in this public place, or denied the right to speak what they feel is appropriate or what their beliefs are, is a perception on their part of a violation of that auditor's rights. One of the things that we have to look at is you look at some of these audits, and I'm going to show you a couple of examples in my presentation today, is, are they doing anything wrong? Is this really suspicious activity? Or is this a person on a sidewalk in a public lobby where other citizens can be at, just filming or taking photographs of random issues there? It's a social movement categorized by these auditors. They look at themselves as citizen journalists that are testing the constitutional rights, and their constitutional right that they believe they're testing is this ability to photograph or video record in a public place. They also believe that their record of these interactions is promoting transparency and open government. Law enforcement response has been varied from basic question and answer kind of interaction to arrests, to detainment, to confiscation of equipment, to allegations of assault. And as a result, various, for one example, the International Association of Chiefs of Police has put out some guidance to their members, basically stating that the use of a recording device alone is not grounds for arrest unless other laws have been violated. There's a reference down at the bottom of the page there that the International Association of Police has put out that's given some guidance for law enforcement, some basic trainings for law enforcement on this issue, on just how to respond and how to address these type of situations. But one thing that they do stress in all of these discussions that I've researched is that these auditors still do not have the right to intervene in law enforcement interactions or law enforcement duties to ensure public safety in their specific roles. So what do we look at here? Well, they know where they can be. You will typically find them on a sidewalk, on a street. Maybe it's an alleyway around the outside of a governmental building, or in a public lobby area or in a public hallway. Those areas that are open to the public is where they will be presented, where they will be at, and they know their boundaries. The conflict typically arises when a governmental official, law enforcement, a supervisor, a manager of an area will challenge them, and they'll challenge them by saying, "You can't be here." Well, it's a public place. You can't film here. It's a public place. There's no restriction of the recording of this area, the things that I can see within my site. They will typically respond to questions about what are you doing, or why are you here, or why are you filming, with the response of, it's for my personal use. I'm a private journalist. In some instances, when they are approached by particularly law enforcement and they're asked for their identification or their name, they'll either be silent or they'll choose not to respond, or I choose not to give you my name at this point in time. In fact, what you'll see in some of the videos that I'm going to show here is that they will start turning the questioning onto you. What is your name, sir? What is your position, ma'am? What is your badge number, officer? And so instead of answering the questions, they will start asking, or start trying to take control of the situation and start asking questions. And you have to ask yourself, is this really the activity that this person is conducting them, or the manner that they're conducting themselves in? Is it suspicious, or are they just a citizen in a public place doing some video recording, if you will? Arrests have occurred for a variety of reasons: obstruction of justice, or disorderly conduct, or other perceived types of criminal behavior. And again, the perception of what is really going on here is something that has to be stressed with people in a position of authority, particularly law enforcement, of what is the actual criminal behavior or misconduct that this person is in fact doing. One of the things that I found this reference from a gentleman in Colorado Springs, he talks about that the activity appears to be suspicious in some instances. In fact, one of the videos that I'm going to show you, an officer asked this auditor, can't you see how this activity would be suspicious? And the auditor's response was, well, I am permitted to film based on your policy or based on the law, and you have video recordings on the building right here now that all the public is being seen. Why would that appear to be suspicious? Again, you can see how they turn the question back to the person that's asking or the person in the position of authority. This video recording, you may have a person that is working a counter in your office or in your agency, and they are uncomfortable with this person that walks into your public lobby or into your area to start filming this person or filming the interactions with citizens. It's uncomfortable. We don't understand why they're doing it. Your employees, citizens may be concerned over what's going on. But again, we have to keep in mind, it's a public area and there is no restrictions as it goes to filming or recording in these public areas. I've already mentioned that they will stay in they know their boundaries, the public areas, sidewalks, streets, lobbies, hallways of governmental buildings, post office buildings. They know their boundaries and will stay there. Often they will recite various statutes, various case law, attorney general opinions. If you have a policy that addresses these issues in your particular area, your particular building, they will cite that, and frequently they will offer to show it to you. They will have a copy on their person in those instances. One of the things that I've noticed in the variety of videos that I've reviewed, and I'm going to show you here in a second, is the way that they present themselves. Sometimes it's very positive, it's very respectful, but it can quickly turn to someone who presents a very negative attitude, very baiting of questions. If they see that they're starting to get to you, they will continue on with those types of questions or those type of comments that further upset you, if you will. One thing that I've told young officers over my career is that somebody has to be the adult in the situation. Be calm. Be calm. It's just a person that you're asking, what are you doing? How can I help you? Oh, okay, you're filming. Okay, is there anything I can assist you with? Just be calm and just be the adult in the situation as you interact with these persons. This gentleman here also suggested some of the problems that we encounter in addressing these First Amendment audits, if you will, is rushing in or immediately engaging the person without really seeing what's going on and understanding what's going on. Yes, you have an employee that's upset or they're uncomfortable. This person is filming. I understand that. But let's take a look and see what is this person really doing? They're filming pictures on a wall. They're filming the lobby area. They're filming people coming and going inside this public area. They're really not doing anything wrong. So to rush in and become judgmental before you are certain about what actually is going on or the scenario that's going on can sometimes be problematic. Being uncertain of what the authority is or what, for law enforcement, what applicable charges might apply in this particular interaction or engagement that you're facing with here. So understand just exactly what's going on. Again, I've talked about getting into this debate, this challenging over what you can and can't be doing or where you can or you cannot be. Someone has to be the adult in the situation. And certainly don't remove their recording devices, don't seize, don't destroy their cell phones or cameras or whatever property that they may have. I did some research and found this source here, Citizen Video Audits, Knowing Their Rights and Yours, and they point to 7 different things that seem to make a lot of sense to me. The first thing that they talk about is that these First Amendment auditors will frequently misinterpret the law. And they gave a good example here that I'll of one point that I'll just speak to, and they reference Terry versus Ohio. And Terry versus Ohio requires that an officer possess specific and articulable facts providing reasonable suspicion of criminal activity before detaining somebody. So what the auditors have interpreted this to mean is that when a law enforcement officer engages them, they must identify specifically what it is that they're doing wrong or what they perceive them to be doing wrong. That's a misinterpretation of the law. Now, while many law enforcement officials, when they stop or they engage a citizen, they may ask, do you know why I stopped you today? This is what I saw. That's fine, even though that they're not required to do so. But just one example of it is that the officer doesn't have to necessarily spell out exactly what this person has done at this point in time to ask some basic questions. They refuse to self-identify, to tell who they are. Some states have enacted some stop and identify statutes or requirements where the person must present identification or identify who they are. I found this Attorney General's opinion dating back to 2004 on the right side of my PowerPoint here. And the question to the Attorney General was, does a court officer serving civil papers have the same authority enjoyed by police to approach a person in a public place and ask the person to identify themselves? And the answer is yes, they do. However, they can't compel that person to comply with the request unless that officer has reasonable suspicion that the person is engaged in criminal wrongdoing. So in Tennessee, there has to be the suspicion of criminal wrongdoing in order to identify that person. Keep in mind, they're in a public place. They're on your sidewalk. They're in your public lobby. They're filming a picture on the wall. They're filming maybe a trophy case in your area. They're not doing anything wrong at this point in time. Popular targets, initially, they were focused on law enforcement agencies, jails. Now they look at a variety of government buildings. They look at airports. Post office are another common target, courthouses to take a look at. One thing to bring up here is in 2010 and in 2018, the Department of Homeland Security published two memorandums that directed federal law enforcement not to detain persons who are filming their facilities absent some other indicator of criminal activity. In 2018, that memorandum, the second memorandum came out that permitted them, citizens to come inside the interior of federal buildings into public access areas to film, and that officers are frequently finding themselves unprepared to address some of these audits. There's also a U.S. Postal Service poster number 7. And if you were to go into your local post office, you would see it hanging where there are other memorandums and there are other posters inside the post office that specifically connects back to or refers to this 2018 memo that permits for these First Amendment auditors or these auditors to come in and film your lobby area or the counter area of the post office. The unfortunate thing in several of the videos that I reviewed, some of the postal workers that worked in those areas were unfamiliar with that memorandum and found themselves on the negative side, if you will, of that First Amendment audit. Auditors and bad words. Sometimes people will say things or make comments that we do not appreciate. They will make comments in a tone that we don't appreciate. Does not necessarily mean that it's criminal. In fact, the use of profanity or derogatory language is not necessarily a crime. Again, here's where we have to think about being the adult in the situation. And if we approach them in that positive manner or that professional manner, many times the audit just sort of moves on, and there's a passing grade, if you will, just to move on and not to engage or not to further stir up the issue that's going on. One thing the courts have recognized is this use of fighting words, if you will, and one of the things is, as far as law enforcement goes, we're trained to address people who try to use these words to antagonize a situation. And again, I go back to use restraint, be the adult in the situation, and be it that you're dealing with this particular person. Their favorite question is, am I detained? Am I free to go? And one of the things that they'll frequently do is if they get that answer, well, you're not being detained, they'll immediately turn and walk off. And what that does is sort of stir up that frustration, if you will, a little bit more with law enforcement to be a little bit more agitated what this particular agitation they're involved with, or interaction that they're involved with. The next question is, how close is too close? There was an example of a traffic stop in San Diego, California, where an auditor walked up to video record this police officer and this citizen engagement for this traffic stop. The officer asked this First Amendment auditor to take a step back, to give them some space. The auditor took a step back. The officer asked them again, please step back. And the auditor said, well, the Supreme Court has ruled that 10 feet is all I have to give, the distance that I have to give. Well, first off, there's been no Supreme Court ruling on a 10-foot distance. But secondly, what law enforcement has to understand is that it's their safety, it's the safety of the citizens, it's the safety of the community that they're responsible for. And if they feel that there's more distance that's needed to give, get that distance, have them step back. As the courts have ruled or engaged that these auditors do not have the right to interfere with a law enforcement engagement or law enforcement operation at that point in time. You might get sued. We have discussion, having spent a lengthy career in corrections, we can have allegations of wrongdoings for adhering to our policies and procedures. We can get allegations of against us for doing the right thing, just as much as we can get allegations of doing the wrong thing. I did do some research, though, to try to see if there was any lawsuits that have actually been settled as it relates to First Amendment audits. And there's a handful. There's not a lot out there, but there is a handful. And a couple examples, in 2018, Colorado Springs, they settled for $41,000 on one failing audit, if you will. Also in 2018, Manchester, New Hampshire paid out $275,000 when a gentleman was recording his interaction between himself and law enforcement. In 2020, there was a $9,500 settlement after an engagement in a community post office. And then one that was a little bit lengthier period of time ago, in 2012, Boston, Massachusetts settled for a $170,000 settlement. The other thing that I did read as I was preparing for this is that some civil rights attorneys are looking for some of these cases, and for two specific reasons. First off, they feel that this is sort of some low-hanging fruit. There's clearly a unlawful detention in these incidents, and these incidents are recorded. And there's typically some of the responses being provided by law enforcement or by that public official is totally inappropriate in what is said. And then the second thing that they're finding is that many, because of the compelling evidence against this agency, the agencies are just willing to settle, and therefore the attorneys get their attorney fees over this very easy settlement that's going on that has been well recorded in these audits. The various rights typically center around freedom of speech, freedom of the press, unreasonable search and seizures, right to remain silent. And what the courts are basically saying, that as long as a person is in a place that they can be filming in a public area, if you will, does not constitute in and of itself a reasonable suspicion to detain that person, probable cause to arrest that person, or sufficient justification to demand identification. And again, I connect back to the Department of Homeland Security 2018 memorandum that basically cites the same thing as far as law enforcement engagement. This lady here is from the Colorado Intergovernmental Risk Sharing Agency, and she talked about that these audits are carefully planned. And I've already mentioned that they know what their restrictions are, they know what their boundaries are. And so they'll be in an area where they can legally be. There's no law or restriction about recording a public building in a public place. But one of the things that she stresses is that these interactions will sometimes be uncomfortable. Your employees, you are uncomfortable with this camera that's in your face, or this camera that is filming across a business counter, if you will. But we have to be careful. I mean, is it something that they're doing legally wrong? Is it a place that they shouldn't be? Or are they just a citizen in a public place video recording? And she said just to sort of walk cautiously, remain calm in your interactions. The former jail administrator of Dixon County, Amy Logden, interacted with one of these auditors. And she basically, it was a positive interaction. One of the things that she asked the auditor to do was not to film a group of inmates that were on a work detail on one edge of the parking lot. And she said, just out of respect for their privacy. And the auditor said, okay, that's fine, I will. And they continued on. But Amy gave some guidance to her staff is that, wave at them, say hello, just ignore that they're there in those instances. They're doing no wrong. So I have a couple of videos here that I want to show you. And here's one in Nashville of interaction between law enforcement and one of the First Amendment auditors. And I want to show you a couple clips here.
Hey, Jim,
Yes.
there's no sound, so you may have to stop share and then make sure that you click on the play audio and then share again.
Hey, Nikki, I've lost my control panel here.
Okay. There you go.
I got it. I just came.
Okay, perfect.
So you said stop share and try it again.
Yeah, and make sure you select the option to, I think, capture the audio, the media audio. Now go ahead and put it in slideshow. And then if you want to click on slide number 9, where your first video is, and then select the option that says play from current slide.
I want to make sure enough click the volume.
Hey, Jim, we still can't hear the audio for it.
Okay.
Nikki, is there an option for Jim to send us the links?
Yeah, if he has them, or I guess for the sake of time, since it's actually 10:15, if he's okay with sending out the PowerPoint presentation, the video should be embedded in the PowerPoint presentations.
So Jim, if you want to bypass your videos and just put them in your PowerPoint, and we can send that out if y'all want to go ahead and go into your Q&A.
I am. I'll just conclude with the final PowerPoint.
Okay, sounds like a plan. Thanks.
So there was there were three clips I was going to show you. The first clip was very basic. The officer interacted with the gentleman outside the Nashville Library. The conversation was very positive encounter. The officer asked what he was doing. He said he was filming. The gentleman asked for the officer's name and badge number. He provided him. The gentleman talked about that Department of Homeland Security memorandum that I referred to of 2018. They had a very positive discussion. The officer explained, just as long as you remain in a public area, the public lobby, you're good for him. And so he passed that audit. The second slide clip occurred in the one of the Nashville area libraries, and the two librarians challenged the auditor that he could not be filming in this public library. The auditor and they cited a policy that they had that restricted it and required him to get permission from their central office to record. Ultimately, the gentleman asked them to go to their computer and take a look on their computer of a specific policy that was published by the public library system that permitted him to do this. So the employees were citing a policy that they were not familiar with, and he pointed them to the actual policy that permitted him to do so. While they got a failing grade, it was a positive interaction by everyone, and there was no necessarily frustrations expressed, if you will. The final one that I wanted to show you dealt with a TSA at the Nashville Airport interaction that was got to become very agitated by a TSA representative. His supervisors engaged. They explained or they understood that there was the Department of Homeland Security memorandum permitted the filming of this TSA checkpoint. Yet this gentleman was still very agitated and felt that they had no authority to film him and demanded law enforcement come on site to address the situation. Law enforcement came on site. They interacted with the gentleman, and there was they concluded that he did have the authority to be there, and just basically they all said have a good day, shook hands, and they moved on. So my example was to try to show you that there were some very positive interactions, even though they may not have known what they were talking about, but some interactions that got very serious and very agitated. So as long as these auditors have the right or the ability to film in a public place where they're legally allowed to be, they can film basically whatever in that plain sight or in their view. There was an example that I found in California in a police department that the agency put out a memorandum that said that they can be in their law enforcement lobby at any time to film anybody at any point in time. And some of the counter to that is that if you had a citizen that was in that lobby that was a victim of a crime and they were filing a complaint and there was some obvious emotion as a result of this crime that they had just become victimized by, some common sense has to step in. To give that person that privacy, either move that citizen to a private area or ask that auditor, please step outside while we address this person's issues here. So common sense has to step in some of these instances. In your areas, identify and provide notice of what restricted areas that you may have. An example I gave is a tour of a 911 building where a 911 director stepped outside, asked the person what they were doing. They said, "I'm just filming for my own personal use." The 911 director said, "Would you like a tour of our building?" They took them through the building and they got to one door that had a security sign on it. The 911 director says, "I can't allow you to film inside this area because of the sensitivity of operations that are going on." The auditor said, "Thank you, I appreciate that." And they continued on with their tour and went out. So it's appropriate to have some restrictions. Maybe you have a counter in you have a little vestibule in your office area with a counter where your employees work from, where the typical citizen is not permitted behind the counter. Well, the same would apply for this auditor. They can be in the vestibule area, but not necessarily step behind that counter. Again, use common sense. And as you look at this, is just consider what harm is occurring. Are they just a citizen in a public place, or are they doing is there some form of misconduct occurring? And finally, consider or discuss how these audits will be handled before they actually take place. A good example, and I apologize for the technical difficulty here, but a good example is to look at some of these YouTube videos and just develop a little bit of a role play where you can have one of your employees play the role of an auditor and have another employee engage them and just see how the situation can move on in a positive manner, or how it could lead to further questioning or further challenges. So if you have a policy regarding the filming or recording in your public area, make certain that you understand it. Make certain that you discuss it with your employees. Make certain you discuss it with your new employees. Again, it may be an uncomfortable feeling, but you have to ask yourself, are they really doing anything wrong? Or are they just a citizen in a public place videoing or photographing your areas? And again, I apologize for the technical difficulties. And that concludes my presentation.
Do you all want to go ahead and open up for questions and answers at this time? Did anyone have any questions? I know I did see one in the chat feature. I think the first one, is there a so-called agency that employs these auditors? How are we to know if a person is an auditor? That was one of the questions. So if you guys want to take a look at the chat, there's a couple of questions there.
Sure. No, there's no real agency per se that these people are employed by, or that's sort of coordinating them. These are just individual citizens that are out there that have decided to test their right to be in this public place and to test their right to video things that they can see from that public place. In fact, I found a couple that have set up some GoFundMe accounts to get people to pay for their expenses as they travel to different areas. The other thing is that they will do a follow-up audit sometimes, as they will, if there was an audit, for example, that TSA audit that I was mentioned just a few moments ago, they went back to that same checkpoint about a month later to see how it went then, to see if they would get that passing grade at that point in time. And I noticed that someone else put here, I have put signs in the office, is this that says authorized personnel only. Is this sufficient? Yeah, I think that that's sufficient, or this is a restricted area, but you have to be prepared or think about that is this area, or this authorized personnel area, can the public still access that area? So for example, if you had and I'll use the little vestibule area in many clerks' offices, if you will. If you put the sign on the outside of the door that says authorized personnel only, well, you have to ask yourself, can't the public enter into this vestibule area? If they can, then the sign is probably placed wrong. Now, if you place the sign up by the counter where the restriction is behind that counter area, then I think that it would be appropriate. And I gave the example of the 911 facility where they had a restricted access only on one door to enter in that particular area. A prime example of that's appropriate. But you have to think about in your policy or in your procedures, the why. Why do we want this specific area to be restricted? we can't just say the building is restricted. Why are these specific areas restricted?
Did anyone have any more questions? Jeff, did you have anything else?
There's a question about drones.
Yeah, I see the question about drones. We don't deal with drones a lot because that's not really regulated by the county government, but there is a statute. You want to write this down, whoever asked the question. It's Tennessee Code Annotated 39-13-903. And that kind of regulates what people can and can't do with drones and how they, where they can take pictures and where they can't take pictures and where they're limited relative to kind of personal surveillance on people's property or people themselves. So if you want to look at that statute, it's got numerous exceptions, but it does have some limitations on what people can do with drones. That would be enforced by the state, but that statute is out there. So there is some limitations on what they can do with drones.
Jeff, if you don't mind, can you put that statute, the TCA code in the chat feature, please, in case someone missed it?
Thank you, Kimberly. That's a good idea.
That's what I'm here for. There's another question from Mr. Smith. What about those that block? Is that egress or ingresses of public buildings and public streets? Not familiar with that word, clearly.
Well, as it pertains to the First Amendment audits, you're not typically going to see that as it relates to this specifically. Typically, these auditors know their boundaries, know their restrictions. Their intent is not to violate the law. What they're hoping that it occurs is that the perception of law enforcement or the public official is that they are violating some law or some regulation. So as it relates specifically to First Amendment audits, they are not going to block egress or ingress of a building, of a public street. They know their boundaries and they're going to stick to them.
And we have about 3 or 4 more minutes left, so we're getting some questions. Is using a body cam considered making copies of public records during an inspection? Jeff or Jim?
Jeff, Jeff, I'm going to have to defer to you.
Is using a body cam considered making copies of public records during inspection? I think what I'm taking from that is you're saying, the way the law is structured, you can't charge for people simply viewing public records, but you can charge for copies. So what I think the question is getting at is, and correct me if I'm wrong, is can we charge them if they're taking pictures of the records? They're making their own copies, or is that something we can prohibit? The Office of Open Records Counsel has stated that you can prohibit people from taking pictures. So in that case, if they wanted copies, they would have to pay you to make the copies. But the Office of Open Records Counsel has stated that you can't prohibit them from taking notes, but you could prohibit them from taking pictures using something like a body camera or just, a camera on a lanyard around their neck or something like that.
There are 2 more questions and then we'll allow you guys to log off because we want to respect your time. Does still photography, does the article also include still photography in reference to audio and video? That's from Beth Stockwell.
Everything that I'm finding is that relates to either the still photography and or the video recording is acceptable in that public place and the lines of sight that they have from that public place that they're at. John Smith, I believe it was, asked about officer safety pending litigation. I actually looked at that, John, to see if I can find anything, and I could not find anything that related to that. The only case that I found was specific to San Diego County, where this distance issue was. Again, they have no authority to intervene or disrupt a law enforcement operation. So that would be the judgment of the officer if they feel that their safety was being jeopardized, or they were intervening in this particular law enforcement encounter, what action that they could take at that point in time. But I found nothing, any pending cases relating specifically to the officer safety issue in these encounters.
And Jeff, did you see that last one? She circled back around and answered your question. She was referencing the inspection. Can they restrict the use of body cams?
Sorry, that's what I thought it was. And yes, you can prohibit them under the, and if you go to the Office of American Counsel's website, they've got a feature that has frequently asked questions with answers. And that's where you can find it on their website if you want something to be able to show that person that says you can prohibit people from taking pictures of the records, which is just kind of their way of kind of short circuiting the process for not paying for the copies.
Okay, thank you guys. We'll go ahead and wrap everything up. Like I said, I want to respect everyone's time. Thank you so much, Jim and Jeff. We will get those PowerPoints sent out to you. If you all can give us until tomorrow midday, we can get those sent out to you. I did put my email address in the chat feature. I will also tell you it's kim.henry@tennessee.edu. If we missed sending that information to you, because I know some of you all didn't get the opportunity to register ahead of time. So you can make the request directly to me, kim.henry@tennessee.edu, and Tennessee is spelled out. You all will also receive a website, a course evaluation. You should already have that in your email by now. Again, if you did not receive that, go ahead and let me know, and I can send that directly to you because it may miss a few of you all. And I think that's pretty much it. We appreciate you all's time, and we hope that you all have, I was gonna say a good weekend, but we're only halfway there. But anyway, when you do get there, have a great weekend. Thank you guys. Have a great day.